In Vietnam, layoffs and redundancy are not purely business decisions, they are legal processes governed by Vietnam's labor code. While companies may need to restructure or cut costs, the law prioritizes employee protection, transparency, and fairness. Employers who implement layoffs without following procedure risk serious legal consequences, including reinstatement orders, severance claims, and public scrutiny. For foreign invested companies, the stakes are higher. Authorities expect strict compliance with both the letter and spirit of the law. A legally sound redundancy plan safeguards not only the business but also its reputation and long-term employee relations. Redundancy and layoffs in Vietnam are regulated under the Labor Code and its guiding regulations. These provisions apply when a company must reduce staff due to 1. Organizational restructuring, technology change, or business model adjustment. 2. Economic reasons such as financial hardship, reduced demand, or relocation. 3. Mergers, consolidations, or divisions of enterprises. The law requires employers to develop a labor utilization plan, consult with employee representatives, and notify the labor authorities before implementation. Failure to follow these mandatory steps exposes the employer to a high risk of unlawful termination findings. The first and most critical step is preparing a labor utilization plan. This internal document outlines how the company will manage its workforce during restructuring. It must specify the number of employees to be retained, retrained, or laid off, the criteria for selection, seniority, performance, job necessity, the retraining and reallocation opportunities offered to affected staff, the schedule for termination and severance payments. This plan must be developed in consultation with the employee representative organization and submitted to the labor authorities for review. Only after official notification can layoffs proceed. LTS law often assists companies in drafting compliant labor utilization plans that align with legal and HR realities. Before layoffs occur, employers must consult with employee representatives or the company union to discuss the redundancy rationale, affected roles, and benefits. Employers must consult with employee representatives and notify affected employees in advance, within a reasonable timeframe, in accordance with the approved labor utilization plan. Transparent communication demonstrates good faith and prevents disputes. Employers should hold documented meetings, issue notices in Vietnamese, and record employee acknowledgements. Once the labor utilization plan is finalized and employee consultations are complete, the company must submit the plan to the provincial competent labor authority. The submission must include the labor utilization plan, in Vietnamese, written explanation of restructuring or redundancy reasons, minutes of consultation with employee representatives, a list of affected employees, including job positions and length of service. The competent labor authority may review the submission and request clarification or additional information if necessary. Only after completing this statutory notification step may the employer lawfully implement redundancy-related terminations. Implementing layoffs without notifying the competent labor authority constitutes a serious procedural violation and may expose the employer to administrative penalties or reinstatement obligations. Employees laid off under redundancy are entitled to severance pay if they have worked for the company for at least 12 months. Under the Labor Code, severance equals half a month's salary for each year of service, based on average wages over the last 6 months. Employers must also pay outstanding wages, unused annual leave, and social insurance contributions. All payments must be completed within 14 working days from the termination date. Proper calculation and documentation of severance are crucial to avoiding disputes and labor inspection findings. When companies merge, divide, or transfer ownership, employees' rights must be preserved. Under the Labor Code, the new employer must continue existing contracts or negotiate new terms. If redundancies occur, the same procedures, labor utilization plan, consultation, and severance, apply. Employers cannot terminate employees simply due to a change in ownership. LTS law regularly advises multinational clients on labor compliance during M&A transactions, ensuring all employee transfers and redundancies comply with Vietnamese law. Typical timeline for redundancy implementation may include draft labor utilization plan within 15 days after decision to restructure. Consult with employee representatives within 5 working days after draft completion. Notify the Department of Home Affairs at least 30 days before implementation. Notify affected employees at least 30 days in advance. Complete severance and settlements within 14 working days of termination. A well-planned timeline ensures compliance and minimizes disruption to business operations. Even large FDI companies often make avoidable mistakes during layoffs, such as proceeding without a properly prepared and notified labor utilization plan, using economic reason as justification without documentation, failing to notify the competent labor authority before termination, applying inconsistent criteria for redundancy selection, calculating severance incorrectly or paying late. Each of these missteps can lead to reinstatement orders, fines, or class action claims. In redundancy matters, precision is protection. Layoffs are not only a legal issue, they are also a reputational challenge. Transparent communication and fair treatment reduce tension and maintain trust with remaining staff. HR should coordinate with management to explain the business rationale, retraining opportunities, and compensation clearly. Documented communication, bilingual where needed, demonstrates professionalism and compliance during inspections. A European manufacturer in Binh Duong faced declining orders and needed to reduce 80 employees. LTS law developed a full labor utilization plan, conducted employee consultations, submitted documents to the competent labor authority, and prepared bilingual notices and severance calculations. The layoffs were completed smoothly, inspected by authorities, and confirmed as compliant. No disputes arose, and operations continued uninterrupted. The key to success: documentation, timing, and fairness. At LTS Law, we specialize in designing lawful redundancy and layoff strategies for employers in Vietnam. Our bilingual lawyers prepare labor utilization plans, employee notices, severance calculations, and the competent labor authority submissions. We also train HR teams on communication and documentation best practices. Whether you're restructuring, downsizing, or merging, we ensure every step complies with Vietnam's labor code and reflects global HR ethics. In Vietnam, layoffs are not simply a business choice. They are a regulated process that demands transparency, fairness, and compliance. A well-drafted redundancy plan protects your company from disputes, penalties, and reputational damage. If your business is planning restructuring or workforce reduction, contact LTS Law today. We'll help you design a compliant, humane, and risk-free layoff strategy that meets both business goals and Vietnamese law.